Now we are going to discuss three prime issues in today's lecture. The first issue is that what are the changes in this law? The second issue is what are the consequences of those changes? And third is, which many people have been asking, that when this law will apply, when it will be enforced. Now, while discussing all these three questions, I will discuss auxiliary, incidental, supplementary issues also, as and when required. But I must say in the beginning itself that this lecture is just for your information and for your insight about new law. I will not be going into details of law because that will consume enormous time and energy. Time you do not have right now. But if you listen to me right now very carefully, I hope you will understand the nuances of this law. And I firmly believe that this law is cakewalk. And you can remember every bit of it. I remember. I will show you today how to weave the entire IPC in golden thread. Basically, these are different islands, and these islands are connected islands. And if you see them in a holistic manner, you will appreciate and understand why these 20 chapters are there. Now, you have seen arrangement of earlier IPC. But this new Bharatiya Nyaya Sanhita, which has come into existence but not in enforcement, has changed the character of penal law in some sense. And this was necessary. See, it is said generally, you must have read many jurists, and they say that law reflects the thoughts of current generation. I read somewhere Thomas Jefferson said, every generation has its own wisdom and it must be respected. And this tendency of revering your forefathers and past is good, but it should not be absolute. So IPC was beautifully drafted, it was carefully crafted, but there was need of change in that IPC. And Bharatiya Nyaya Sanhita 2023 obviously reflects that necessity. Now, if you read the statement of object and reasons given by the current government, the Honorable Home Minister of India, who presented this bill which became an act by golden signature of the Honorable President on 25th December 2023. Now, he presented a report which says a comprehensive review of criminal justice system in our country was a need of hour to bring it on par with contemporary aspirations of the people. Having taken a citizen-centric approach, the proposed laws serve as a reassurance to the Indian citizens. What is reassurance? What is citizen-centric approach? We'll be investigating, inquiring when we go into detailed discussion of this new Danda Sanhita that is called the Nyaya Sanhita. It says clauses in the proposed Sanhita have been rearranged. So we'll look into this rearrangement also. I'll tell you. Now he says that first point which he mentioned, I want you to understand this reflects contemporary aspirations. Aspirations. Then he says it has citizen-centric approach. We look into all these aspects one by one. Then he says that what we did, he says we rearranged. So rearrangement is one of the main focus. And then he says that we prioritized certain offences. Obviously so. We have read that Janni Janbhumischa Swargadapi Karyasi. The beloved mother. We are paying respect to them. And that is why we begin with this offences against woman and child. You know, even Indian Constitution in Article 15, Clause 3 says that nothing in this article shall prevent the state from making any special provision for women and children. So women and children have been given priority in the Constitution. They have been given precedence in IPC. So this priority was necessity. See the arrangement, many people will appreciate and many people will find it very difficult, but nothing is difficult. As I said, Janani, the beloved mother. Obviously we all owe to mother. Just after that you see there is offense against human body. So the whole human owes its birth to beloved mother. Just following woman and a child we have human body. And all humans create society and state. Just after that you will see the state. And a state cannot exist in isolation. Its boundaries have to be protected all around. The Army, Navy, Air Force is the necessity. Just following that there is Army, Navy, Air Force. See the beautiful arrangement. Can we exist in a state just by protecting our external boundary? You can deal with the trans-border aggression by Army, Navy, Air Force. But can you deal with your own people by Army, Navy, Air Force? No. So to deal with people, to heal the people, we have made arrangement of representation. And this representation comes through election. So see the arrangement. I'll come back again to this point, how this IPC has been beautifully drafted, or rather now Bharatiya Nyaya Sanhita 2023. I don't think that anybody will find it difficult to keep this in mind. The beautiful arrangement of this Bharatiya Nyaya Sanhita. And elections cannot be held without money. You know, there was discussion of electoral bonds. There is huge issue of election funding. So just after that we wrote coins, currency, stamps by which, now stamps, big source of revenue. And can you conduct election without the support and effort of public servants? No, just after that. And whenever you do something, you will commit some wrong. So we wrote offences by or relating to public servants. See, whenever you work, wherever you work, you will get appreciation, you will get criticism. It happens with everyone. And you will be disrespected, you will be disobeyed. Ideal is not real. We talk of Ramarajya. Ramarajya is basically a concept of ideal society, where teacher, student, parents, children, brother, sister, brother, all should maintain cordial relation and they must be respectful to each other. But does it happen in today's society? We are always busy in disrespecting and maligning each other. It is our habit, but we go to temple. I remember Kabir, he always said this also. But let us come back to this, what this BNS does. It says the Sanhita has been streamlined, overlapping sections have been merged. Yes, this is one of the important aspects of this IPC, and that is how this IPC now has become shorter. 20 chapters, only 358 sections, which was there earlier, 23 chapters and 511 sections. I'll tell you where has been this merger and amalgamation. This interesting way of looking into Bharatiya Nyaya Sanhita. Now then it says, definitions is scattered from section 6 to 52. This is another. So, definitions. That was not basically general explanation, though we wrote general explanations in Macaulay's code, but that there were definitions, like now death has been defined in section 46, life has been defined in section 45. Now, similarly, many terms have been defined in that innate, gender, 9, number, 10, man, woman, 11, person, 12, public. Nothing great, you will remember it very easily, it's in rhythm. Now, I have said in many of my lectures that whenever you listen to music, you find a rhythm there. In all arrangement of barracks, there is a rhythm, and in entire body of law, there is a rhythm. If you can find that rhythm, you will enjoy the subject and you will learn the subject easily without any effort. It will be effortless exercise of learning. But for that, you will have to make some effort. So it says, definitions is scattered from section 6 to 52, that is general explanation, have also been brought under one section now. And mostly this is in section 2. This is what I am adding. Section 2 has 39 subsections. I am not looking into any facts and figures. I am looking into this point only, what are the now government's report and what the Honorable Home Minister says on this point. Now then it says further, this is their report. This is basically their report. I have just marked and I am bringing this before you for your proper learning. It also says, whereas 18 sections already stand repealed. Now this will be interesting to see what 18 sections have been repealed. 4 sections relating to weights and measures are covered under the Legal Metrology Act 2009. The proposed Bharatiya Nyaya Sanhita seeks to change the nature of law towards providing justice rather than punishment. This is a very interesting question, that this Bharatiya Nyaya Sanhita, which has enhanced punishment in many cases, and it has prescribed minimum punishment in many cases, minimum punishment in many cases. So when it focuses on punishment, how it has transformed its body from penal code to Nyaya Sanhita. It's a very interesting debate. I would like you to discuss, debate, deliberate upon this issue. But that is again a matter of discussion. So that separate session will be held. Now it says that what are the newly added provisions? The newly added provisions are various. And this lecture is particularly for this purpose, that what are the changes. So if you ask me without going into this government report, I will tell you what are the changes. Now, if I begin from the beginning, I find the change in the name. Indian Penal Code is now known as Bharatiya Nyaya Sanhita 2023. So, if I talk of the work of this Bharatiya Nyaya Sanhita, my question is, did it change? No, no, no. It is doing the same task for which it was enacted earlier and for which it has been enacted now. It is defining the offences, it is punishing the offences. It prescribes definitions, it prescribes penalty. That is the whole purpose, sole purpose of this Indian Penal Code. Obviously, if you ask me, how does it deliver justice? I tell you, justice has many ways and mechanisms. It can be by prescribing punishment, it can be by imposing some penalty, it can be by imposing some compensation, it can be by restitution. Now, justice can be done in various ways. And if you see on the time scale, you will find even the ways and means of justice has been changing. Retribution to compensation to punishment. Now, various ways, there are now various ways and means through which this society has passed, and the way of delivering justice has changed over the time. Obviously, this may be one reason why they have changed the name from penal to nyaya. They want to do nyaya, that is justice. But the question is, can you do nyaya in case of offenders without punishing them? Generally speaking, no. I will not go into jurisprudential debate here, because that is not the scope. But I am very clear in my mind that if you want to do nyaya, you will have to impose some kind of punishment penalty. And that is what this IPC does. Many intelligent people will raise question that if it is so, why did you change the name from penal? You could have written Bharatiya Danda Sanhita, Nyaya Sanhita. Now, I tell you, there is some importance of the name itself also. India was secular before, India is secular now. And Ram is the epitome of secularism. India was secular, is secular, will remain secular. But then we wrote this word in Indian Constitution's preamble in 1976, Vide 42nd Amendment, 1976. So just saying that the name has no meaning, has no importance, will not be fair. Will not be fair. So we are just now putting emphasis on the point of nyaya. That is the focus point. Let us move further. So definitions in one section, that's beautiful. Before I move further, I must tell you here the change. See, if you see carefully the earlier IPC's arrangement, I'll give you a comparative chart in our Bare Act, so that, and don't worry, Bare Act will be published very shortly. And we are working on it because it's a Herculean task, it's not easy. Many publishers have published Bare Act because they have not written anything in that Bare Act, but we are writing quite a lot. Why this, why that, what is the comparison? So there are many nuances where we are required to look into, and we are trying to avoid all kind of errors. So that is why we are taking too much time. So if you have seen earlier IPC, you would have found that chapter 1 of IPC earlier was from section 1 to 5. But now it is contained in section 1 itself. So see, 5 sections have been merged into one section. So merger is one of the important aspect of this new Bharatiya Nyaya Sanhita 2023, Act number 45 of 2023. Now it is there in section 1, it is there in section 358. I was saying that if you see section 1, now in section 1 you will find that section 1 has many subsections, 6 subsections. So all earlier scattered sections have been clubbed into one now, that is section 1, and section 1 has many subsections. And I draw your attention particularly towards section 1, subsection 2. Now what it says, it answers your one important question. It says it shall come into force on such date as the central government may by notification in the official gazette appoint, and different dates may be appointed for different provisions of this Sanhita. So this Sanhita will come into force when the central government will announce date of enforcement by official gazette notification. And it may happen that different provisions will apply on different dates. Now, if you ask me personally, I think there is no issue in enforcing this Indian Penal Code, barring that section 106 on which there is some kind of dispute between the vehicle owners, especially truckers, and the government, because there is one novel provision in form of 106 subsection 2 which punishes hit and run case. But barring these few exceptions, there is no question and there is no confusion. Government can enforce it anytime. So it will not pose much difficulty, because all earlier committed offence will be governed by old IPC and new offences will be governed by new Sanhita. And I hope as an informed citizen, and especially people from legal fraternity knows this very well, that generally criminal law does not have retrospective operation. This is constitutionally prohibited. Article 20, clause 1 you have read in Constitution. So you cannot enforce punishment or offence from the back date. And there is no use, no point, because already there is criminal law of IPC. So that will not serve any purpose as such. But then why we wrote this, that different provisions may apply on different dates? Because there may be some issue regarding some provision, because these are new experiments, new experience. So there may be some kind of confusion, debate. Now there may be some kind of issues from somebody. So they have taken this chance that will apply it now, maybe in a staggered manner, but I don't think so it is going to happen like that. And if you see the last provision of this IPC, that is section 358. Now if you see section 358 of Bharatiya Nyaya Sanhita, it again gives you a very important piece of information. It says IPC is hereby repealed. It says it is repealed. It says, so this talks of enforcement. And if you see the last provision, section 358, it says IPC is hereby repealed. And then it says, notwithstanding the repeal of the code referred to in subsection 1, it shall not affect the previous operation of the court so repealed or anything duly done or suffered thereunder. So whatever has been done, that will remain operational and that will remain valid under old IPC. So this law will have prospective operation, not retrospective. It will not apply from back date, it will apply from future date. Any right, privilege, obligation or liability acquired, accrued or incurred under the code so repealed. So if I have right to be punished less, you cannot punish me more. Any penalty or punishment incurred, I have already been punished under old IPC, will you punish me in new Bharatiya Nyaya Sanhita? No. These are all general, normal, natural conclusion. And I think any person who has prudent mind, who has reasonable understanding, who has logical brain will appreciate this, that if I have punished you once, why I will punish you again? There is concept of double jeopardy also in Constitution, Article 20, Clause 2. So this is in consonance with constitutional provision. Then it says any investigation or remedy in respect of any such penalty or punishment. So already investigation or remedy which was there in respect of penalty or punishment, that will remain operational. Then it says any proceeding, investigation or remedy in respect of any such penalty or punishment as aforesaid, and any such proceeding or remedy may be instituted, continued or enforced. So if anything has begun in old IPC, it will continue. So again and again, what is the whole sum and substance of this all reading, which might seem to be now a little difficult for you to retain in your mind right now, but there is nothing great. It's very simple, logical conclusion that whatever has been done, whatever has begun, that will be governed by old IPC. And whenever we'll enforce BNS, prospectively, that is for future time, it will apply to those situations, those offences. It's as simple as that. Subsection 3 says, this is beauty of law. It's a fascinating subject. So in 358 subsection 1, you said that IPC is hereby repealed. Great. Obviously BNS will come and IPC will be repealed. So, and now in subsection 3 you say, see, this is how law is continued. It says notwithstanding such a repeal, anything done or any action taken under the said code, the IPC, shall be deemed to have been done or taken under the corresponding provision of this Sanhita. It will be considered like murder has been committed there. You have been given punishment in section 302. Now it will be considered that the murder has been committed in this new Bharatiya Nyaya Sanhita and you have been punished under this new Bharatiya Nyaya Sanhita. So it has been done. So this is what is 358, repeal and saving. So your question of enforcement is already answered. And whenever it will be enforced, then there will be question of it's being asked and it's being discussed in the court and being asked in the examination, being asked in the law universities. Till that there is no question. If you ask me today's scenario, there is no BNS. And I tell you, that many people have created a kind of rumor in air that the BNS has come into operation. And many students, many lawyers, many judges have started believing that without knowing the basics. And this is why I remember that our Honorable Chief Justice of India said that what kind of people we are having right now in our fraternity. They are not having basic knowledge, basic understanding of the subject, and they are occupying the post. And why this is happening? This is due to online culture, this is due to Dukki culture, this is due to series culture. Because nobody is interested in reading the textbook, nobody is interested in devoting the time in understanding. If you want to study law, IPC will consume your 40-45 days at least. CRPC will consume 3-4 months. How can you do it in 10 days? So there is no shortcut in law. It requires maturity, it requires understanding, it requires patience. But if you are running with the subject, then you will never understand this. So this is how, and I saw one reel which was shown by my daughter to me, that one boy has said something about some section and he has 800,000 likes, perhaps, just for speaking baseless statement that BNS has been applied. And people are liking it because people are ignorant. And that is why I remember Acharya Rajneesh. He says that nobody is taker of truth in this society. If you speak truth, nobody will listen to you. Mr. Ranjan, he told me one day, if you are teaching the students, tell them all lies, that without studying they can become judges. They will be very happy. You tell them this. But if you tell them that I will teach you for 1.5 years and 2 years, and then I will guarantee you passing of examination, they will not listen to you. You tell them 2 months, you will become judge. I have jadoo ki jhappi or jadoo ki chhadi, whatever you have, like Sambhabaj. But I said I will try to convince my student in this way, but it's very difficult for me to speak lies because I am Ram Bhakt. I can't speak lies. I'll speak truth. Section 1, section 358 clearly says BNS has not been applied till date. Obviously, it should be applied. I am also waiting for that. CRPC may have complication in application, but IPC or BNS doesn't have complication in application. CRPC has. Bharatiya Nyaya Sanhita will have complication in application because it will require mammoth infrastructure. It will require support. It will require a huge number of judges, huge vacancies. Obviously, huge vacancies is expected in judiciary because of this reason that you are going to enforce Bharatiya Nyaya Sanhita 2023. Act number 46 of 2023. But we'll discuss and debate it in another session, but let us come back to this. So I was talking of that what are the changes. So I told you that enforcement is very clear. Now, if you come to this section 2, I said all sections of 6 to 52 or 52A has been now merged into section 2, and that is how the number of sections have gone considerably down. Not only down, it's considerably down now. So you see 6 to 52, almost you have 47 sections in one section, that is section 2. Almost I said because there are many provisions which are inserted in section 3. Many provisions in section 3. Now going further. See, this IPC had changed its arrangement because earlier you had preliminary, then you had this general explanation, then you had punishment, and punishment also in old IPC. If you look into old IPC, you will find, my dear friend, that starting from 53, you will go till 75 in punishment. So, see, 23 sections almost. And whenever you are required to know the number of sections, there is one formula, very simple. This is 22 sections. And as you have now deducted 53, so you will have to count 53, so it will be 23. So this is 23 sections, not 22 sections. Don't do this mistake. Now 99% law students do this mistake. If you ask them how many sections are here, so they will tell you 22, 75 minus 53. So where is 53 now? Now you have to insert 53 also, include 50, so 22 plus 1. So this is 23 sections. Now these 23 sections of punishment are now in this 4 to 13. So hardly 10 sections. So see how we have reduced the number. If you are asked this question, how did you reduce the number? This is the answer. 6 to 52, 52A, we have in one section, that is section 2, or some sections in section 3, almost in 2 sections. Punishment, 23 sections, you are now having it in 10 sections only. So we considerably decreased the number of sections, considerably. This is how you will get the idea of arrangement also, idea of arrangement. Now then, if you go further, now see, one by one, if you see this carefully, now see overview of Bharatiya Nyaya Sanhita. It's not difficult to memorize this. I can speak without looking into this. So it is not a big deal, I tell you, but you will have to practice. You will have to master this art of learning. Master the art of learning. I said that section 1 has 6 subsections, by the way. So they are section 1 to 5 in section 1 now. And I said section 6 to 52A or 52, whatever it is, of old IPC is now in section 2 and 3. Punishment earlier 53 to 75 is now in section 4 to 13. That's very clear. Now you come to general exceptions. Now general exceptions you will not find any change in IPC. So there is no need of memorization at all. If a student asks me today, what is this section 14, I can tell you this is same as section 76. What is 15? Same as 77. What is 16? Same as 78. What is 17? Same as 79. This is magic. And there is no magic, there is logic everywhere. It is arranged in the same manner as old IPC. Even arrangement is not changed. So when you say that arrangement has been changed in entire IPC, you are not perfectly precise. Everywhere we have not changed the arrangement. You see one instance, it's before you. Section 14 to 44 is 31 sections and 76 to 106 in IPC is 31 sections. It's written almost in that order, and when you see IPC, the CRPC and evidence, you will find the same. It's very easy to remember. So all your anxiety evaporates in second. If you ask me today, 32 minus 6, what is this minus 6? I'll tell you, just have patience. 26. Where is the 33, old 33? It is in 27, I know. How do you know, sir, this? I know, because I have made the method of that. I have gone deep into the subject, I have understood it, I have planned the way how it is to be presented, how it is to be kept in mind. So I said 14 to 44, there is no change. Same as old. So this task same. Ajay sir, can you tell me, when you said that section 2 contains many of the definitions, how will I keep that in mind? I'll tell you in great detail, but not right now. But let me tell you very clearly that Macaulay's draft did not follow that alphabetical order which was expected to be done. But in new legislations, we follow alphabetical order. So if you find even in IPC, you will find alphabetical order now. And that is why there was need of change. There was need of improvement. You are required to improve. If you think that you understand IPC, you come and meet me also. If you think that 299 clause A and 300 firstly is same or different, I will make you understand what is the truth. Somebody says that there is difference in degree of intention. That is what has been taught in the universities. I have been taught. But is it the truth? No. It is absolute misconception. There is difference in degree? I can't believe this. So you will have to make some effort for that. That's my sincere suggestion. There are many learned people who have made effort and they understand better than you and me. But there are many of our friends who do not appreciate. Now then see, you said, sir, you said me about general exception, tell me about abetment, so many sections are there and I can't remember that abetment is very difficult concept. Okay, I was not aware of this. I thought abetment is very easy. Because I generally abate students in my class in positive way to study, not in that abatement which is written in IPC. I induce them, I instigate them, I encourage them to study. Sir, abatement, how is the order? Same. Oh, unbelievable. So abatement, how many sections, sir? 107 to 120. Okay. And there was 108A. So how many sections? This is 15. This is 15 section. So exactly 15 sections are written here. No, एक थोड़ा ज़्यादा है. There are 18 sections here. If you see abetment, conspiracy and attempt, why did you write this in one block? Because these are all inchoate offences, incomplete, inchoate, legal language, incomplete. Inchoate offences have been clubbed together. Before I enter into offence, I write incomplete offence. Before contract, agreement has to be there. Before murder, culpable homicide has to be there. There is an arrangement, you will have to understand. So before I go into offence, I have written incomplete offence. So why are you memorizing this? No, I have been trained since my childhood to memorize everything. You memorize, that's your discretion, I can't help it. But I will not memorize, and I will not recommend memorization even of subsection and comma and full stop, and I will memorize better than you. That's my challenge. In the sense that I understand, I do not memorize. I said abetment has exactly 15 sections there. 107 to 120 you count, these are 14 sections, 108 is in one addition, that is 15 section. Here you will find in abetment 16 section. Why it is so? Now see here, 45 to 62, these are 18 sections in total. I told you 62 minus 45, 17 plus 1, 18 section. So in 18 section, attempt is 1, conspiracy is 1, so abetment is 16. So you will raise a very simple question. Okay, please explain me why there are 15 sections and why here 16 sections. I tell you, my dear friend, if you want to understand a concept very well, raise right questions. And raising right question is an art. It's a skill which is to be developed. And that is what I am trying to develop in you. And this is what is one of the main purpose of my sitting in this class. So you will raise a question, why there 15 section, why here 16 sections? So I'll tell you, my dear friend, see, the makers of this Bharatiya Nyaya Sanhita 2023, Act 45 of 2023, thought it better that if you abate something in India where offence is to be committed outside India, then it is punishable. But what about those things where people are doing something in foreign territory, on foreign soil, to affect India here? How to punish them? What about those abatements? So we inserted a new section now. Now you will ask me, obviously, sir, wo kahan hai? Where is that? So that is in section 48. So 48, see, if you do this exercise, you will memorize everything. Where are the amendments? I am not required to memorize anything. And the rest are the same in arrangement. You just go and check it. I am not required to memorize anything. There is no problem in understanding the arrangement of this Bharatiya Nyaya Sanhita. You may find it difficult because you are not trained. I will give you a very simple example. Have you seen a gymnast? You must have seen. Their bodies are so flexible. They can do any kind of thing. But can you, can me, can everyone? No, because they are trained. Somebody asked me to sing a song. I said, I have never been trained to sing a song. But you ask me how to memorize sections of Bare Act. I bet I can memorize anything. That should be section of IPC. I am not saying about the lyrics. I can't memorize. I am very poor at that. I mix songs whenever I am compelled to sing in my friends group. So I cannot utter now exactly even 2-3 lines because I have very poor memory of songs. But I have very sharp memory of sections. So you have to train yourself. I am trying to train you. Abatement clear, and when abatement is done, then conspiracy was there in IPC, you remember that? See, the same arrangement we are following, abatement, conspiracy. We will not miss even the arrangement and then attempt. So 62 should be attempt, I will not remember, 61 should be conspiracy, until 60 it should be abatement. If I am wrong anywhere, please forgive me for that. But you just check it and let me know through your comments. Now, moving further, you will ask me, why earlier so many chapters and why now these chapters? And how these chapters? And what are the changes also? So, I will be now taking these twin issues in my speech of next few minutes. See, offences are basically made to protect your interest. If you have understood law, if you know law very carefully, I will not go into that detail, but there was, or there is, understanding of pactum subjectionis, where the government says to the governed that I will protect your interest. And if anybody interferes with your interest, I will come to your rescue. If this is your guarantee, let us identify the interest first. Let us identify the interest first. A more important interest, it should be given precedence. And this is what this BNS does. Beautiful one. I said, Janni Janbhumischa Sargadapi Karyasi. So see, in specific offences, apart from general principles, you can see the chart on the board. I have categorized them into general principles and specific offences. General principles obviously are the general in the sense that they will apply everywhere. Obviously, abetment can be done of any offence, conspiracy can be of any offence, attempt can be of any offence. Now, general exception will apply to all. The very first section of general exception says that. Earlier also it was written. Now, rather, first section of general explanation, section 6 says that. Now, similarly here it is written. Similarly it is written here. So, there is no worry on that point. It is very simple, plain, general. So, if you see the arrangement of specific offences, I said we have given precedence to women and child, or woman and child rather. It is written in plural, it is written in singular. It is not women and children, it is woman and child. Woman and child, not women and children. So, woman and child has been given precedence. Obviously, in that category of offences, you will have offences relating to women. Now, you just think of. So, you are just required to think of. You are not required to look into your barracks always. Because that is forced learning. You learn by your own wisdom. You apply your mind. What are the offences against women? It may be sex related. It may be sex related. It may be marriage related. It may be force related. You just think of. I am talking of primary offences. Now, dowry death, marriage. Bigamy, marriage. So, all those can be clubbed together. And here you will find that here and there we have improved, or rather let us say we have transformed the provision for betterment of law. For betterment of law. And we have clubbed many provisions, we have merged many provisions to make it simple and straight. And that is what we have done. See, offences against women and child. Now, some people will say that how will I remember sections, sir? Not a big deal, I tell you, my dear friend. Let me close my eyes and let me speak a little bit. Now, chapter 1 is section 1, 2, 3. There is no teleprompter here. Chapter 2 is section 4 to 13. Chapter 3 is section 14 to 44. Chapter 4 is section 45 to 62. So, chapter 5 is section 63 to 99. See, sometimes you have to apply your mind. 6 plus 3 means how much? 9. So 99. And see, I have my own methods of learning. For that I have to think and I have to devote time. I tell my colleagues also here that you people come and you people sit here and then study, as it seems that you are doing some official work. But I sit at home and I study, and then I come here and I study further. So I am whole day into study in that sense when I am taking class. So I was just thinking how to tell my students to memorize the next chapter. So I just thought, see, life comes from zero. And obviously it results into death sometime. And I remember in IPC I read section 46 is death. So it began from 00 and it goes to 46. Obviously we have come till 99, so obviously it has to be 100. So 100 to 146. Then I faced next question. How will I convince my students or my friends in fraternity that how to keep in mind the next chapter? So I thought of another method. Now these humans, obviously they have been given guarantee by state, and these humans create a state, pactum unionis. You and me, all of us. What is India? Or what is Bharat for that matter? We are. You and me. And see, this is a question of giving precedence also. What is important? Janani, important. Child, important. The beloved mother and the beloved child. And then human body. And then this human body now organizes or creates a state. Obviously, state cannot exist in isolation. As I said, it needs some kind of support, some kind of force to protect itself from trans-border aggressions, and that is why Army, Navy, Air Force. See the arrangement. And then I said, how can you run the government? How can you run the state? So this Army, Navy, Air Force will not run this state because it's not police state. And neither the police force can run the state. So it has to be, it's a democratic country. So elections necessity. So see the chapter's arrangement. And this is how we are moving. 5 women and children, 6 human body, 7 state, 8 Army, Navy, Air Force, 9 elections. Can you conduct elections without money? So 10 is coin, currency, stamps. So see, this is in proper order. And now, in election you have one big challenge. And what is that? To conduct election in peaceful manner. If you conduct election, but there is bloodshed, there is violence, then this is no election, public tranquility. And who will do this? Who will maintain this public tranquility? Obviously, the public servant. Obviously, when they will act, they will commit. They may commit. So we have written offences by or relating. And they will issue certain guidelines, orders. So obviously there can be contempt also. So just try to understand how to weave entire IPC. Now you may ask me another question. Okay, I got the arrangement. Now what about sections? So I can't tell you right now, you will have to wait. There is method of memorizing sections also. I have told you till 146. I told you that. I can tell you even further. But this lecture does not permit me to do that. I will not enter into that exercise. So just look into the screen. Don't take too much pressure on your mind. I hope you have understood what I am trying to communicate, how this is woven beautifully. It's beautiful one. This was offense against women. Let us close this. You come to that chart and just brainstorm and guide yourself that how will you keep in mind the next few. So there is nothing great. It's just a matter of exercise. It's a mere matter of practice. And we know it, practice makes a person perfect, but I will not say perfect, better. Practice makes a person better. So see, you have reached till this point. Now see, obviously when you interact with public servants and you disobey him, that is what is written, contempts of lawful authority of public servant, obviously you will be charged, prosecuted, punished. Obviously question of trial will begin. Now you just think of in the periphery of Indian Penal Code or in periphery of Bharatiya Nyaya Sanhita, what kind of offence is likely to be committed when you are being tried for contempt, for disobeying the public servant. What kind of issues may come in picture when you are being tried? Obviously you are being tried for the offences, but you may give false evidence. You may create false evidence. You may fabricate false evidence. All these issues come in trial. You just guide yourself that how can I keep this in my mind? And then obviously now see, these are the issues now related to your society. The offences, as I said, see your interest, you have your interest in your body, you have interest in your state, you have interest in your maintenance of public order, you have interest in obeying this or maintaining the order in society where public servants are issuing orders and they are giving you directions. So these are all going to maintain harmony and order in society, and that is why we have made these offences. It is not that it came in my mind and I have written something. There is a lot of thought behind it. If you do not give proper evidence, can we conduct proper trial? Can we maintain order in society if you do not obey the government, public servant? So that is why contempt of lawful authority. This was applicable even in old IPC. Can you maintain in harmony in society without maintaining this decency and morality and religion? Now you know these days many offences. So these are society specific. This is how you have to learn. And see, the whole Mahabharata was fought for some piece of land, that is property. If Duryodhana would have given them half of the empire, that would have been justice. But even when they were denied this half of the empire, they said we need only 5 villages. Even that was not given. And that is why Mahabharata came in picture. So you are talking of, you have huge interest in property. If I do not have property, how will I survive? I need it. And it is one of the necessity of our life. If I can't protect, now see, many jurists have also said that violence to property is the major reason of breach of law and order. And you will find many property related offences, and due to these property disputes you have many murders also. Because nobody is interested in killing somebody, everybody is interested in snatching the property. So offence against property, offence against property. See, this is property related. And last but not the least, intimidation, insult, annoyance, defamation. It disturbs you or not? If somebody insults you, how bad you feel. Somebody intimidates you, threatens you, how bad you feel. So we have clubbed them together. IPC over. So now you understand the arrangement of this Bharatiya Nyaya Sanhita. Now, I discussed with you till this abatement, criminal conspiracy and attempt, the change. I said section 48 is the new section which has been added, and why it has been added. I told you that why it has been added. Now, if you see carefully, now what are the changes I tell you? Abatement outside India for offence in India. A person abates an offence within the meaning of this Sanhita who without and beyond India. You are sitting in Karachi, you are sitting in Washington, you are sitting in Dubai and abates commission of any act in India. It was not punishable earlier, so it is new. And it was required or not, tell me. It was required. And if you see just now before that, that is 47, that was old 108A. That if I abate a crime in India to be committed outside India, then it is punishable. But if somebody abates a crime outside India to be committed in India, why he should not be punished? And see, there was a provision in your old IPC also in section 4 which says that if computer is located here, resource is located here and you are interfering with my computer from somewhere outside India, you will be punished in India. Section 4 of IPC. So on the same analogy we have written this. Now, sexual intercourse by employing deceitful means. Now, this has been now judgment of Supreme Court in many cases that many of the people obtained consent of the lady by giving false promise of marriage, promotion and other kind of benefits. So now section 69 says whoever by deceitful means, beautiful provision, by deceitful means or by making promise to marry a woman without an intention of fulfilling the same, has sexual intercourse with such woman, such sexual intercourse not amounting to the offence. Now, see, there is consent, but consent has been obtained by making false promise to marry. By deceitful means shall be punished with imprisonment of either description for a term which may extend it to 10 years. And shall also be liable to fine. So this is a new provision. Section 69, I will request you to write down this, what are the new sections, so that you can see it on your own, even in government barracks. Now then, now see this new Bharatiya Nyaya Sanhita. Listen to me carefully. This new Bharatiya Nyaya Sanhita has introduced many provisions which are now gender neutral. Now, when we used to discuss earlier 354 and 354 A, B, C, D, we had many questions and confusion in our mind that why offence of now this disrobing and now voyeurism, etc., cannot be committed by a woman. Can a woman not commit offence of disrobing against a woman? Can a woman not commit offence of voyeurism against a woman? I have my dignity, I have my respect. Woman has her dignity and respect even against a woman. But that was byproduct of a special situation where a man commits offence against women and there is great furor in entire India. Hue and cry was raised. And hurriedly we did that. But that is how you learn from your mistakes. Now see, section 76 and 77 is answer to that mistake, and now we have corrected it, improved it, and we have written whoever. It's not written any man. whoever this is disrobing. Compelling her to be intention of disrobing or compelling her to be naked shall be punished with imprisonment of either discretion for a term which shall not be less than 3 years. Similarly, voyeurism. So, this has been made gender neutral now. This has been made gender neutral now. Hiring, employing or engaging a child to commit an offence. See, here also earlier provision, it was girl child, but now whoever hires, employs or engages any child to commit shall be punished with imprisonment of either shall not be less than. See, here it says very clearly, using a child for sexual exploitation or generally this will be now maximum majority of cases it will be committed against woman child, but this can be committed even against a male child. So, again section 95 is gender neutral in that sense. Now, punishment of murder, mob lynching, you have heard, mob lynching. This is what is here. We have not given name of mob lynching, but this is what is written here. Mob lynching, 103(2). It says, when a group of 5 or more persons, you remember that, you are not required to remember again, now you know about unlawful assembly. Whenever a group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, because many murders these days have been committed on the ground of race, caste, community. This has been now really worrisome situation in the society where we have been talking of that we are moving in right direction and we have this Rama Rajya. So, there this kind of thing should not happen, and government has taken initiative on the point and has said, group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief or any other similar ground. Each member of such group shall be punished with death or with imprisonment for life, and shall also be liable to fine. So, this is what is mob lynching, 5 or more persons committing this kind of offence on the ground of race, caste, community. We have heard that many people committing murder here and there. Punishment for murder by life. Now, see, there was section 303 earlier. You may be aware of that, section 303 earlier. Section 303 IPC, which was declared unconstitutional by Supreme Court. On what ground? That you have prescribed only one punishment of murder, only one punishment of death. But now we have removed this infirmity. We have removed the infirmity on the ground of which Supreme Court held that law unconstitutional, and we have said, whoever being under sentence of imprisonment for life, the person under life imprisonment, commits murder, shall be punished with death or with imprisonment for life. So, this thing, the change with death or with life imprisonment has made this provision reasonable. Earlier it was arbitrary. Earlier it was arbitrary, now it is very much reasonable. It is in consonance with constitutional requirement of reasonableness. Arbitrariness and equality are antithetic to each other. Equality and arbitrariness are antithetic to each other. One belongs to the rule of law and another to the whim and caprice of an absolute monarch. So that you know, Justice Bhagwati in E.P. Royappa versus State of Tamil Nadu, 1974 Supreme Court decision. Causing death by negligence, a novel provision has been introduced. The punishment has been enhanced. Now, in many provisions, the punishment has been enhanced. That will require another exercise where you can learn that in which provisions punishment have been enhanced. That is now again the matter of another session that we'll have to have. But here we cannot do that, but I'll just show you here also. See, causing death by negligence in 304A earlier IPC, 304A IPC earlier, it was only hardly 2 years punishment. I tell you, it's very interesting story, because earlier now, when this IPC was drafted, the car lobby and the vehicle lobby was very strong, and Lord Macaulay's draft, when they now brought this negligence, death by negligence, so that included obviously hit and run cases also. So that was protested at that time. The car manufacturers protested, the vehicle manufacturers protested hugely, and that provision was removed from original IPC of 1860. It was only after IPC was enforced that in year 1870, this 304A was inserted, and that too after so much of hue and cry, and that is why it provided only minimal punishment of 2 years. But now that Supreme Court and other courts have been saying that in hit and run cases, even in now Salman Khan case, that one court said that he was not driving a vehicle, he was basically driving a death machine. And many other cases where the court said that 304A should not be applied, it should be 304 at least, that is culpable homicide not amounting to murder, considering the fact that 304A has very little punishment, that is 2 years. So now it has been enhanced to 5 years. And furthermore, the provision of controversy, this is 106(2), because here you clearly say, whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting it to police officer or a magistrate soon after the incident shall be punished with imprisonment of either description of a term which may extend to 10 years and shall also be liable to fine. Whoever causes death of any person by rash and negligent driving of vehicle. So you have clearly written that rash and negligent driving of vehicle resulting into death of somebody will be now addressed by virtue of this 1062, and where the punishment may be up to 10 years because you did not report it to police or magistrate. So 10 years. Obviously, if you report it, 1061 may be applicable there. If you take care, 1061. But if you do not take care at all, 1062. Now, moving further, what are the other changes? Other changes. Organized crime. There are many syndicates acting in concert. Huge paraphernalia. Gangs. In Bombay, there have been culture of many bhais. Chota bhai, bada bhai. So many bhai. So you see, any continuing unlawful, including kidnapping. Now here it is said, here it is kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offences, cyber crime, trafficking of person, drugs, weapons, illicit goods and service, human trafficking for prostitution, ransom. So these are the crimes which are committed by syndicates. We have seen this in past and we have brought it here. So that is how it is in sync with contemporary requirement. So it says kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offence, cyber crimes, trafficking of persons, drugs, weapons or illicit goods or services, human trafficking for prostitution or ransom. So these are serious crimes. Now in comparison to this, if you see 112, this says petty organized crime. See, this is how we understand. That was organized, this is petty organized crime. Now it says act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting, gambling, selling of public examination question papers or any other similar. Now examination papers, paper leak everywhere. We also wait for paper leak or connection with someone to pass the examination, but this is unfair. Let us prove our worth. So these are small, theft is there, snatching is there, cheating is there, unauthorized selling of tickets. You have seen that. Unauthorized betting, gambling, selling of public examination questions. So this is what we have learned from the past, that these have been offences. So these are new things which have been brought in IPC. Now, if you see carefully, in 111 you have these 7 clauses. Can you see this? Now, there are 7 things which is being punished. Even the conspiracy attempt has been punished, abetment. Even somebody who is concealing, supporting, harboring, they have been punished. Even who is getting the benefit of that organized crime, he is being punished. So that is why if you look into the words here and there, harbors or conceals, see, derived or obtained, see, it says any person is at any time in possession of movable or immovable property for which he is not giving account, cannot satisfactorily account for. So, a person harboring, deriving benefit, and who has some property out of that and he is not able to give proper account of that. So, they are all covered here. Who is member, even membership is punished. Whoever attempts, now this is inchoate crime, they are also punished. So, this is why we have so many sections. So, this is inchoate crime, this is membership, this is who harbors, conceals them, this is who derives benefit. This is why you have so many petty organizations. Then see terrorist act. Now, again the question which is raised, that why you have defined a terrorist act is already there, covered in UAPA, etc., and there are many other laws. So, why here? See, IPC is comprehensive law. IPC is now one of the major criminal law, and we have given very wide connotation to these things here, though they are special laws like UAPA or other terrorist laws are special laws. They deal with that issue only. But IPC doesn't deal with that issue. It deals with issues related to this society, issues related to your interest. And see, fortunately, unfortunately, if you see the setting of these sections, it is in which part? It is in offences against human body. So, there is a lot of discussion and debate which will be happening in future, but for the timing, let us see this. What it says that now whoever does any act with intent to threaten or likely to threaten unity, integrity, sovereignty, by using bombs, this, because, and why it is given here, it says, little bit justification, death or injury to person, loss or damage to property. So, even loss or damage to property is covered here in terrorist act. Because you are using bombs, dynamite or other explosive substance. This is an important point to note down. Disruption of supplies or services essential to the life of community in India. They must have seen movies also. In movies, you have seen many things like that. They will stop supply of medicine or something like that. They will not allow them to go. Terrorists. So, damage to or monetary stability of India by way of production or smuggling or circulation of counterfeit Indian paper currency. Happens. So, you are learning from past and you are doing it here. Then damage or destruction of any property or in any foreign country intended to be used for the defense of India. Damage or destruction of any property. All right, so this is what is terrorist act. But as we have mainly this death, or that is why you have written this in offences against human body. I do not understand much relevance, but I cannot speak much right now on this point. Now, 117. Why I have written it here, voluntarily causing grievous hurt? See, this is again a provision where you have made it very simple in the sense, or you have merged many provisions. If you see comparative chart, you will find that in hurt and grievous hurt earlier you had these sections 319 to I hope 338. But now you will find few sections here. Why? Because this, if you see carefully, this was hurt and grievous hurt earlier, IPC. This is in IPC. But now if you see in section 117 you have written 4 subsections, and similarly in other sections you have written many ones. Now you see section 117(3) or 4, basically 4, group of 5 or more persons acting in concert. This is again mob lynching, though we are not giving any name of mob lynching anywhere. But this is how we have learned from the past, we have seen in the past, and we have provided in this BNS. 117(4). Seven years. Now this is again very important, 117(3). It says that if you cause grievous hurt and create permanent disability or persistent vegetative state, shall be punished with rigorous imprisonment for a term which shall not less than 10 years, but which may extend to imprisonment for life. Then another new provision, importation of girl or boy. Now see, this is again gender neutral. Gender neutral. From any country outside India, any girl under the age of 21 or any boy under the age of 18, with intent that girl or boy may be, or knowing it to be likely, they were may be forced or seduced to illicit intercourse with another person. So this has been made gender neutral. Shall be punishable with imprisonment which may extend to 10 years. So 141 again gender neutral. Both boy and girl can be victim. Earlier this was in section 366B of IPC. Which was not gender neutral. Which was not gender neutral. Now earlier we have written here in section 95, I hope, some similar point. Hiring or employing or engaging a child. This was earlier in 366A of IPC. This is again gender neutral. It may be an interesting fact to know that what are the offences which have been made gender neutral. I said this 76 and 77 is gender neutral. Gender neutral. 76 and 77 of BNS. Earlier in IPC it was not so. In IPC it was not so. Now 152, again very discussed provision, which was earlier in the form of sedition. Now that name has been removed. There are changes also. Act endangering sovereignty, unity, and integrity. Whoever purposely or knowingly by words, either spoken, written, or by signs or by visible representation. Now, electronic communication will be added everywhere, or by financial mean or otherwise excites or attempt to excite cessation, that is separation, or armed rebellion, or subversive activity. Now, subversive activities is a wide term. Subversive activities. Encourages feeling of separatist activity or endangers sovereignty, unity, or indulges in commits any such act shall be punished with for life or with imprisonment which may extend to 7 years and shall also be liable to fine. So similar to that, but not exactly same. Subversive activity has been a bone of contention in the sense that this is wider expression, and you can insert or you can bring many things here. So that is being criticized, but nothing doing. This is the law in Bharatiya Nyaya Sanhita, section 152. Earlier it was known as sedition, 124. Attempt to commit suicide is not an offence now. This has been removed in IPC, in this Bharatiya Nyaya Sanhita. Attempt to commit suicide is not an offence. Attempt to commit suicide is not an offence in section 309. So now what is written here in 226, a new provision, it says attempt to commit suicide to compel or restrain exercise of lawful power. You must have seen many people self-immolating. No, they go into self-immolation. They pour kerosene and now diesel and petrol, and then they put themselves on fire, something like that. You must have seen in many government offices just to put pressure on the government machinery. So it says whoever attempts to commit suicide with intent to commit or restrain any public servant from discharging his official duty shall be punished with simple imprisonment for a term which may extend to 1 year. So we are treating them with all sympathy. But it is not attempt to commit suicide in general. No. It is attempt to commit suicide to compel. And then snatching, that is just after theft. So I was discussing this, I said snatching. You see, snatching has been introduced in this new Bharatiya Nyaya Sanhita for the simple reason that this offence has been on rise. And whenever you see the newspaper, you will find every day that some people from motorcycle came and they snatched the lady's mobile, purse or golden chain, something like that. Mobile snatching, chain snatching, purse snatching is very common. And this was offence, I tell you, in this state of Haryana. Already it was there. So theft is snatching if in order to commit theft, the offender now suddenly or quickly or forcibly seizes or secures or grabs or takes away from any person or from his possession any movable property. It can be anything, any costly thing. So this has been added just after theft. If I remember correctly, it is section 304 and theft is in section 303. So these are the additions. I must tell you what are the additions again. What are the changes? Where are the changes? Section 1, section 2, section 3. Now, one most and very important change is in section 4 also. That is community service. Section 4F. Section 4F, community service. It's good kind of change, because now people should have some kind of feeling that they belong to this community and they must serve community. But many people do not have this desire. They always look for their own benefit, and we are highly selfish in that sense. As Hobbes correctly said, man is by nature nasty, brutish and selfish. But this community service tells you that you must serve the society and you should pay back to the society. But we do not have time for society. And we have been trained and we have been told not to indulge in affair of society. If two people are fighting, you don't go there. This is what we have been told, but I am of different mindset. You should stop them, you should tell them not to do it. And the rest I have already told you. Mob lynching, I told you, hit and run cases 106.2, mob lynching I said 103.2 and this 117.4 also, mob lynching. Organized crime 111, petty organized crime 112, terrorist act 113, subversive activities 152, attempt to commit suicide to threaten public servant, that is 226, snatching we have just seen 304, and I must tell you that I said correctly that section 76, 77, 95, 141, all these have been made gender neutral. and obviously we are talking of accused. See, there are certain provisions which have been deleted or repealed also. Like 124A is one, you know this. 497 is another, that is adultery. Though adultery is the repealed, but some people say that you have reintroduced adultery in some way in this section 69. How we have introduced adultery in some way in section 69, I just tell you a little bit thought. That they are saying that whoever by deceitful woman, by making promise to marry a woman without an intention of fulfilling the means, had sexual intercourse with her. So, whoever by deceitful means or by making promise to marry to a woman, so it is not unmarried woman. Bigamy is a different offence, I am not concerned with that. So, some people say that this is one way or the other you have brought adultery from back door. That this offence can be committed even against a married woman. Section 69. See, this is way of interpretation. So, section 497 repealed, section 377 repealed, 124A repealed. So, you have seen that there have been many mergers, and I tell you that one of the beautiful aspect of this IPC, that if you see IPC now this BNS carefully, Bharatiya Nyaya Sanhita carefully, you will find that in many cases offence and punishment has been written together. It was unnecessary to write punishment separately because they now increase the number of sections. So, generally you will find that now definition and punishment has been clubbed together, generally. Generally it has been done. Obviously, general explanation you have seen that has been brought under the definition head, so that is what I have already told you. I think this is what is the change, and if you ask me about the consequences, I think this change is for better. And we did not change the fundamental principle of criminal law. We have not changed. Mens rea, actus reus will constitute a crime. Actus non facitorium nisi mens rea, that will remain a golden rule or golden thread running through the entire web of IPC. There is no doubt, no confusion in my mind. And you should not have also iota of doubt in your mind. So, that remains same. General exception is same. General principle is same. So, the fundamental basic law of criminal jurisprudence remains same. Obviously, there are changes, new crimes have been introduced, like I said, terrorist act and this organized crime, and this reflects the modern reality. Snatching, you have just seen snatching is also there. So, these are reflection of, and whatever drawbacks were there earlier, like 76, 77, 95, 141, which were not gender neutral earlier, now they have been made gender neutral. Now, there are certain drawbacks also. See, any system will not be without drawback. Can you be perfect? Perfection is godly. It's not humanly possible. Even if you say that I am perfect, you are not perfect. So, expecting that this Bharatiya Nyaya Sanhita is perfect, it is not correct. This is the era of gender neutrality. This is the era when we are talking of civil liberties. And you did not make marital rape a rape. I am not saying that this is very easy, because it may open Pandora's box also. It may result into breaking of many families. At the spur of moment, you can file a case. So, how it is going to solve the problem, I am not sure, but this is one of the criticism that you did not make marital rape. Now, an anomaly has been corrected. Earlier, somewhere 15 years, somewhere 18 years, CRPC 18, IPC 15, so now we have done it 18 years. So, that is another correction which we have made, and correctly so. We have made this correction in this Bharatiya Nyaya Sanhita. So, this is a beautiful point. Community service has been introduced as a way of punishment, this beautiful point. In many sections we have enhanced punishment, we have prescribed minimum punishment in many of the provisions. Minimum, which was rare earlier, it's now not rare now. It's in many provisions now. At least this much punishment will be awarded. And see, you will find that in many provisions we have now written and fine. Earlier it was many provisions or fine. Now it is and fine. So we are moving from punishment to justice. It will require further debate, discussion, deliberation to understand it even deeper, better. But for the time being, I hope I have answered the question. I have already answered the question that when it will be enforced by government notification. It is right now not applicable. Now, as far as if you are asking any question, any student listening to me, let me complete. Judicial Services Examination will bring these matters when it will be enforced. Because you cannot ask question on those laws which are not in operation. This will be futile exercise. It may happen that it may not be enforced. Who knows? But generally it is likely that it will be enforced very soon, at least Bharatiya Nyaya Sanhita. But you should not worry at all, because I have already told you general exception remains the same. Murder provision, it remains the same. There are many beautiful things which have been done in this Bharatiya Nyaya Sanhita. As I was telling you, let me tell you little bit on the beauty of this. I was saying that, see, now many offences, like you see these offences against women and child, just holding you for a few minutes. See, I said you just change the way of learning, and you see, what kind of offences against women? Sexual, criminal force assault, marriage, miscarriage, and child. Miscarriage was earlier in chapter 16 of IPC, though it is offence basically against women. Even women can commit, but if somebody is forcing her to miscarry, this is against her. Marriage, obviously woman is the victim. Criminal force and assault against women, it is not against men. And sexual offences, victim can be woman. But it is not exactly correct to say that there cannot be offence relating to marriage against men. I must tell you, the world is changing very fast. In many marriages, women will compel male to earn more. Is it not demand of something like dowry? Many wives will compel their husband to earn by unfair means. I have seen it. And their relation will not be cordial due to this reason that the husband is very honest. Because expectation is very huge. So just saying that this will be committed, I am leaving you the thought. You just think over objectively. Law requires us to be objective, not subjective. I am not speaking against women. I am asking that can there be a situation, or is there any possibility? There can be. So still many things remains to be done. But see this beautiful arrangement, sexual offence was there in offences against body in last one, 375 to 376. Criminal force and assault was there in 354 to 354 A, B, C, D. Then, and 509 also, 509 in that chapter. So that is also here, word, gesture or intended to insult modesty, So this is the rearrangement. Marriage, you had another chapter, chapter 20 of IPC. So this is beauty of this Bharatiya Nyaya Sanhita, that you have clubbed it together, all offences against women and child. So with this thought, I leave you here, and I hope and appreciate that you must have appreciated IPC. Read this Bharatiya Nyaya Sanhita with this lecture, understand it very well, think over, write down on my channel here and there if you find anything to be done further on this particular aspect. Is this all right?